there are so many questions coming from the public at the moment regarding the neutrality of their legal system. For the Supreme Court to be making these kind of observations before they've even heard anything, it's quite unsettling. People are wondering why they've already come out with these observations. Would it be fair for Nupur Sharma to go any further, considering how they're already thinking? She's only exercised her legal right to jump straight to the Supreme High Court. I believe they called her arrogant for doing so. What is your opinion on this at the moment?
So if we just step back for a moment, firstly, let's recognize that the Supreme Court as a body is a number of justices, and it's the same Supreme Court which passed the triple talaq legislation, for example. So it would be unfair to just jump in and tarnish the whole institution. Having said that, it's worth having a look at the individual justices, and I think that's where we start to scratch our heads and just consider whether what we've assumed them to be is actually what they are. I agree with you, firstly, that the observations were completely gratuitous and they were uncalled for. They have, in my opinion, tainted, unnecessarily, they have tainted and coloured the manner in which Nupur Sharma will be received in any subsequent court. And the Supreme Courts, they tend to be very careful with their language. They tend to be very sort of deeply aware that anything they say becomes law. And so it's uncommon for them to be so emotional and especially almost capricious in the way that they have gone over and beyond what was required of them. The issue in front of them was actually quite a straightforward procedural request. She wanted to have all of the FIRs bundled together and treated in one location. She'd asked for New Delhi. For whatever reasons, the court could have said, thank you, but no thank you. We don't wish to do this. End of story. Go back to the High Courts. And that would have been normal. That would have been expected. I'm surprised they made that decision in the first instance. It's an entirely reasonable request for an individual having one incident being looked at to have to run up and down the country going to all the different courts where FIRs have been registered.
Yes.
For that same one incident, it makes a mockery of the principle of natural justice. And so that aspect was unusual, but as I said, justices tend to be a law unto themselves, and so anything can happen in a courtroom. Perhaps he had a terrible night the night before, didn't like the look of the expression on the face of the counsel, and sadly made a capricious observation. But when I look at this, there's another dimension I think it's always worth having a look at. Each of us, especially our dharmic family, we have a connection with what justice is. We know instinctively when an injustice has been perpetrated. We feel it, and then afterwards we understand it. And humanity has this instinct, and what it's tried to do is to enshrine that instinct into words, and those words pretty much are what law is. It's an attempt to capture in language the sense of justice and injustice that we all feel. So it's important for any judgments that come out of the Supreme Court to recognize that that's what they are. One aspect which I do think is a little bit worrisome is that the Supreme Court is a colonial, it's a vestige, a vestigial organ of the colonial power. And there is an element of colonialist supremacy about the manner in which they conduct their affairs. A remark was made by the justice that, by one of the visiting justices, who I think he was speaking at an event in the United States, and he said, we are beholden to no one, we answer only to the Constitution. The Constitution is our deity, as it were. Well, actually, in a democracy, that's not true. In a democracy, the ultimate authority is the people of the land.
Yes.
They are who you answer to, and they are the people who look to you for impartial, wise law and justice.
Yes.
And so the first thing, this allegiance to the Constitution is a bit of an anachronism. There was a time when the British used to pick the justices, and the higher authority above the Supreme Court was actually the British legal system.
Right.
And so when colonialism sort of semi-disappeared, so we think, in 47, that top tier above the Supreme Court was no longer an authority that could be referred to. And so what we have is a Supreme Court which is not, it doesn't seem to indicate that it has obligations to the people of the land, but it has obligations to a piece of paper, which was actually just a cut and paste of constitutions of Wales and other jurisdictions. And the Supreme Court should know that. They should know that the Constitution is not something that was etched in stone by lightning at the top of a mountain, on tablets of stone, and then carried down by some figure saying, God has spoken, here it is. It was something put together by fallible men, and it has a lot of work to be done to it. So that situation, if you bear that in mind, it suddenly makes it more comprehensible that we have a capacity for capricious judgments and remarks made by an institution which still feels beholden psychologically, if subliminally, to a colonialist way of dealing with the natives of India. And this, I think, we saw very much present in the judgment that was made by the justice.
Please remember to subscribe to us and switch on the notifications for this channel. For our other social media links, more content, and to support our work, please visit citti.net. Dhanyavad. Namaskar.